Good afternoon, everyone, or good morning, depending on where you are. Welcome to the third installment of the McGuire-Woods Labor and Employment OFCCP Federal Contractor Webinar Series, Recent Developments for the Year Ahead. Today, our topic is OFCCP's Year in Review, 2018 Trends, Tips, and Takeaways. My name is Brian Barger, and joining me are my fellow Affirmative Action team members Bill Doyle, Bobby Holland, and Micah Schwartz. Thanks to everybody for tuning in. Before we get underway, let me mention a few housekeeping items and then we'll get started. If you're looking at your webinar screen right now, you should see several widgets towards the bottom of the screen. Let me call your attention to a couple in particular. First, you'll see a green meeting materials widget including a copy of the presentation. If you click on that widget, that presentation should pop up. A link to those materials, however, will also be sent to you separately via email, so you do not need to access them or print them today unless you just simply want to. Second, you will also see a purple Q&A feature at the bottom. Please use this to submit any questions that you have throughout the webinar. We'll be leaving all questions to the end of the program, and we'll do our best to get to what we can. However, for any questions that we do not have time to cover, we'll definitely follow up with you individually after the program is over, so feel free to have at it. Please also note that this presentation is being recorded. We'll circulate a link to the recording together with a webinar deck and an evaluation form after the presentation is ended. It would be great if you could complete that evaluation as it helps us improve our offerings. It also helps us, frankly, gauge interest in future topics. In addition, for all attorneys who are attending, CLE credit is in process for approval, and we will apply that credit to the bar number submitted when you originally registered. If you have questions about that, or if you didn't submit your bar number when you registered, please contact Laura Beckner at our firm. Her number is 804-775-7578, or she could be reached at lbeckner@mcguirewoods.com. Her contact information is also contained in the webinar evite that was sent to you earlier. So, that's it for the housekeeping instructions. On now to the year in review. So, when thinking about 2018, just to kick things off, to me, it's a lot like the Netflix movie Bird Box that just came out. I won't spoil it for everyone who hasn't had a chance to see the movie. It's actually pretty decent. But let's just say there are two key parts to that story. Number one, what people think they see with their own eyes is in many instances not accurate, and at times it could frankly just drive you crazy. Second, because of that, many people are just scared to look at anything at all. And to us, in many ways, that's pretty much 2018 in a nutshell for OFCCP. It's hard to look at in many, many ways. Despite this, we're going to try and do that, and our agenda for today is we're going to start out by taking a look at what the agency's been doing and sort of a regulatory recap of 2018. Some of this was covered in earlier seminars that we did in the fall, but we're going to sort of go over that quickly as a refresher about where we stand. We'll then pivot and talk about 2018 enforcement and conciliation trends, what OFCCP is doing in the field, what we're seeing in audits, what the conciliation numbers for 2018 look like, and what they show us for 2019. And then we'll conclude with a discussion about what's keeping us up at night for the year ahead, what we're seeing, what worries us, what we think is coming down the pike. So that's our agenda, and that's what we're going to do. And to kick things off, I'm now going to start off with the agency and regulatory recap. And to lead that, we'll turn it over to Bobby Holland and Micah Schwartz. Guys?
Hello, everyone. This is Bobby. I appreciate y'all joining this webinar. It may seem to a lot of people that the political leadership of the OFCCP has been playing the Bird Box Challenge the entire past 2 years, because they really have put a blindfold on to the difficult issues, and they really have not done anything to substantively fix or address any of the concerns that contractors have really had. So why is that? Well, we are 2 years into the new administration, and the OFCCP has had 3 different political directors. We began with the acting deputy director, Thomas Dowd, and then Mr. Andre Harris was appointed and brought into the position. He only lasted 7 months before he left, and we have a new OFCCP director, is Craig Lien, and he finally he went from acting to appointed here just in the last month, in December. And, I've been fortunate. I've had the privilege of getting to talk with Director Lien a little bit because he's directly negotiating one of the audits that I'm trying to resolve for a client. And he is truly, he does have the heart of someone who wants to help. When I talk to him, he truly wants to listen. He truly wants to understand what the issues are. And he wants to do right for all the parties involved. But as smart as he is and as good intentioned as he is, he has no experience in the Department of Labor or OFCCP. As you see from this slide here, he is primarily private experience and local and state government experience, and that really doesn't translate to the OFCCP very well because you don't fully understand the nuances and the intricacies and how things work. But having said that, this is a personal job to him, and anyone who went and heard him speak at the National ILG would understand that he talked about how this is personal to him because he has experienced disability discrimination and failure to accommodate disabilities with his own children, and he really is motivated to improve lifestyles for those people. In addition to Director Lien, there really isn't political leadership at the OFCCP. They have been relying on lifelong government people who've been there forever. Director Lien doesn't have a collection of people that he could go to with maybe more contractor friendly beliefs, and instead he's relying on advice from people who have been an OFCCP staff member for a long time. And so while there has been a shuffle at the top, there has been no traction. I mean, there's no deputy political appointee. There's no chief of staff political appointee. The lowest level of political appointee is a Schedule C political appointee. There's been none of those. And even if you look at the Administrative Review Board, there have been 3 appointees, but they've all been long-term government employees. No one to come in and, quote-unquote, drain the swamp. No one to come in and make changes. It's kind of the same old, the same old. So there's been changes, but it's only been around the edges. So Mike is going to explain and take over from here and talk about some of the directives and changes that they have tried to make.
Thank you, Bobby. And hi, everyone. This is Micah Schwartz from the Richmond office. I'm going to talk to you today about the directives that OFCCP issued in 2018. And I think the way Bobby put it, work around the edges, is a good description. There were a number of directives in the last year. You can see between this page and the next one, there were actually 12 in calendar year 2018 alone. I'm not going to go through each one. I think that would be too time consuming. Instead, I'll give an overview of the themes that they fit into. Some of this is our effort to categorize them, but it's also OFCCP's effort to categorize them because they have tried to explain how these directives fit into one of 3 themes. And those 3 themes are transparency, efficiency, and certainty. If you want to know more about any of these individual directives, you can see we provide you with a link. Feel free to give us a call. We can tell you more about them. Also, we did presentations last October and December, which dug into these individually in more depth. And we'll send those out to the group again after this call in case you want to take a look at those presentations. But again, just give us a call if you want to talk about any of them individually. So going to the three themes, again, transparency, efficiency, and certainty. These are OFCCP's themes, and a lot of these directives fit neatly into these themes, and so they provide a good rubric for talking about all of them. The broader point here, I think, is while these directives do address these themes, they do so with such ambiguity that they don't really cabin in OFCCP, and so as a result, they don't provide the transparency and the efficiency and the uncertainty that contractors would hope for. It's also worth noting that all of these are, again, just directives. They're policy guidance to contractors and to others in OFCCP. They don't have the force of law. And so when it suits OFCCP to go around them, they still can. Let's take this first theme, which you should see now on your screen, transparency. So that is actually the name of one of the directives, the Transparency Directive. And the last three bullet points on this page come from that directive or relate to it. We can use this opportunity to grade whether OFCCP is really doing what it says it's going to do. It did, in fact, publish a methodology for how it's going to select contractors for audits. It has also published a corporate scheduling announcement letters to provide contractors with early notice, give them a little bit more time to get ready for an audit. And the Transparency Directive provides some roadmap of the sequencing and timing of audits. But again, with enough wiggle room and ambiguity that it doesn't really force OFCCP into any rules that it has to follow. This top bullet point refers to the Predetermination Notice Directive. This is actually the first one that came out last year. In this directive, OFCCP said that it will start using these predetermination notices, which are probably familiar to a lot of you, in all instances in which the agency suspects discrimination. And also that it will require these notices to gain approval all the way up in the national office before they can be issued to contractors. I think it's, whether that actually provides transparency is, I don't know, but not really probably, but it could provide some centralization of power in the national office and maybe a little bit more consistency across regional offices and district offices. The next thing that I mentioned is efficiency. And OFCCP has said that at least three of their directives are intended to further efficiency. The first one is the Focus Review Directive. With this directive, OFCCP is saying that it's going to start doing more of something that it always had the ability to do, but didn't do very much, which was focus its reviews, its audits, on one, but only one, of the laws that it administers. So, for instance, it has announced that it may start doing more reviews that focus only on disability discrimination under Section 503 or discrimination against veterans under VEVRA, but not both. Similarly, with the Verification Directive, OFCCP has indicated that this is likely responding to their concern that contractors are waiting till they receive scheduling letters and then quickly throwing together AAPs. And so they have announced that they will start asking contractors to verify that they're actually creating these programs every year. And then finally, the Early Resolution Directive. OFCCP says that this will lead to efficiency because it may allow some audits to end earlier and not require each audit to proceed all the way through desk audit and on-site audits. And one of the ways in which OFCCP is saying that this will achieve efficiency is because it will allow it will allow OFCCP to resolve issues company-wide across many establishments. Well, that is efficient if what you mean by efficient is calling out an entire company for discriminatory practices and saying that they're doing discriminatory things at all of their establishments if there's only a little bit of evidence showing that they're doing it at one. So the early resolution could be useful for contractors as far as their speed, but it comes with a very big catch that it would actually likely lead to findings of discrimination that are company-wide or across many establishments. And then the final theme here is certainty. For the sake of time, I won't go through all of these. I'll just touch on 3 of them really quickly. This is the area that would be the most helpful in that it could provide more predictability to contractors about what OFCCP considers to be violations of its statutes and how its audits are going to proceed. But again, these are couched with such ambiguity that they don't really provide that kind of direction. Probably the most important one here is the compensation directive. Bill Doyle did an entire presentation on this one alone last December, which, as I said, we'll send out to you. So if you want to know more about that one, it's there. It replaces 307, but again, doesn't really provide a lot of concreteness as far as what kind of methodology the agency is going to use. With the TRICARE directive, OFCCP indicated that they are furthering the moratorium on enforcement of OFCCP obligations against contractors based solely on being TRICARE subcontractors. But the moratorium only extends to 2021, so they'll be back in the same shoes of uncertainty in 2 years. And then the last one I'll touch on here are the help desk and opinion letters directive. OFCCP indicated in this directive that it's going to provide a way for contractors to view the answers that OFCCP has provided to other contractors through its help desk hotline. And then we'll also start issuing opinion letters like other agencies within DOL does. And we'll also provide those online. I think this is a good one to end on because it is emblematic of the others. The help desk answers and the opinion letters will provide earlier answers for contractors and maybe give them a little bit more of an idea of, again, what OFCCP considers to be discrimination and how it's going to handle its audits, but only, again, in this kind of sub-regulatory guidance, which doesn't carry the force of law and which OFCCP can get around if it wants to. And so if you look back not just on 2018, but on the last 2 years, we're 2 years in, there's no new regulations. Instead, there's these 12 directives, which are a lot of directives. But if we have a new administration in 2 years, all these things will go away and we'll be back where we were in 2015. That segues well into the Bill of Rights. So, Bobby, I'm going to pass this back to you.
Okay. So, let me get back a slide there. So instead of regulations that take longer to change and be modified, instead contractors should be excited about our Bill of Rights, I guess, that we have. And indeed, these Bill of Rights give some attractive things to contractors, timely response from the OFCCP, opportunities for meaningful feedback, confidentiality, neutral scheduling of reviews. Those are all things that sound very, very nice, but in reality, it's more hype than it is reality. It's more words than it is action. And because the Bill of Rights, it's printed out on a piece of paper and it's about worth a piece of paper because the next administration can change them at will. And there's no regulations out there to protect contractors. And even the Bill of Rights, how it's worded, it's worded in such a way that it seems like the lifelong OFCCP employees got in there and put their spin on things, and it really doesn't offer the protections that it looks to offer on the outset. So, for example, it says we have a right to receive prompt, courteous, and accurate information during the compliance evaluation. But yet the very next sentence says essentially that our perception of the quality of engagement can be influenced by essentially what the federal contractor is doing wrong. And so if you do not believe you are getting the prompt, courteous, and accurate information from the OFCCP, it's not their fault. It is your fault. You're not providing accurate information, or you're not being timely and thorough, things like that. In addition, it talks about a neutral selection process, and that sounds great. But then the very next sentence is that individual contractors are never targeted, but the OFCCP may focus its resource on a particular industry or sectors, geographic regions, or type of employment practices. So they're not going to target individual people, but they admit that they're going to target a group, an industry, a group of employers. And as my experience has been the last couple of years, if you get hit, you're likely to get 4 or 5, up to 12 audits, depending on the size of your company, because they are targeting certain industries. And that leads nicely into some of the enforcement trends. And I think Brian is going to take over for that.
Thank you, Bobby. Yeah, like Bobby said, when you're thinking about targeting, just keep in mind that OFCCP at the end of the day is an enforcement agency, and like other enforcement agencies of the federal government, it has constitutional obligations that go with that, protections that they are required to adhere to with respect to how they select individuals for audit, what they do in the course of that audit, and whether that audit follows constitutional due process. And with that in mind, that's why OFCCP has always had and is supposed to follow a neutral selection process for how they pick and choose individuals for audit. And neutral doesn't mean it doesn't have to be based on facts. It can definitely be based on information like your EEO1 data as it's compared and modeled against other industry data in your region and things of that nature. But what it's not supposed to be is it's not supposed to be political. It's not supposed to be, as Bobby said, I'm going to pick on XYZ agency or XYZ company. It's not supposed to be sort of designed and targeted in a way that's sort of unconstitutional. And so they say that, but in the same breath, as Bobby pointed out in the Bill of Rights, they sort of incredibly sort of admit that they're going to be focusing resources, staff, et cetera, on certain regions. It's hard to know whether what they mean by that is, okay, once you're selected for audit in a neutral way, we're then going to prioritize personnel, money, et cetera, to areas where we think really need it. Now, that is constitutional. But doing the latter, picking on you in the selection itself, putting your thumb somehow on the scales, either in an algorithm or some other methodology for purposes of selection, well, that's not proper. And when you look at the data for the last year for 2018, it's sort of hard to tell whether they really are putting the thumb on the scales or whether they're just sort of prioritizing things. It's also hard to tell because we don't have a full picture of the audit activity. All we're really seeing are, in many instances, conciliation agreement results. But when you look back at 2018 at the conciliation agreements that were published in the FOIA reading room, that were, quote, financial conciliation agreements, in other words, where people actually paid money and not just a technical violation. What you see are 46 separate reported conciliation agreements dealt during 2018, 52% of which come from 5 industry sectors alone: food service, distribution and processing, pharma, healthcare, security, and defense. They make up over half of the conciliation agreement activity. Now, whether that means they're focusing on that or whether that's just the luck of the draw, who knows? But that's certainly interesting. What you'll also see when you jump down from that is there are 6 sectors that make up the next 33%: manufacturing, medical equipment, construction, federal consulting, communications, and energy and information technology. And the remaining 15%, with 1 conciliation agreement each, come from a smattering of different sort of industry sectors: hospitality, distribution, education, senior care, waste management, parking, and transportation. So it's a lot. It's a lot of activity. So you might ask yourself, so who's left? Is anybody left? Well, yeah, it's interesting enough, at least for the past year, there are some industries that seem to get away with no conciliation agreements, which is fantastic. Finance and insurance, retail, real estate, agriculture, mining, entertainment and the arts, and media. None of them have conciliation agreements during the past 2018 year. Now, some of that may be because there was now audit activity that resulted in the necessity of a conciliation agreement. Some of it may be because some sectors, frankly, just really aren't in the government contracting space, like entertainment, and you don't see as many conciliation agreements. But others may, in fact, have to do with their shifting priorities. So that's what we're seeing on the conciliation agreements from a sector standpoint. I would just say, however, that, again, what you're seeing in conciliation agreements doesn't necessarily mean that that's where the audit activity is. Our sense is, for example, that even though finance and insurance did not have any conciliation activity reported on the financial CAs for 2018, our sense is there is an uptick in activity in banking and finance. Likewise, our sense from audit activity across the country is that there is, in fact, an uptick in activity in technology and also with respect to agribusiness and food service. So we'll have to see what 2019 brings, but that's what we're seeing right now for 2018. If you're trying to get a sense of how this relates to other years, this year we had 46 conciliation agreements for the calendar year. In past calendar years as opposed to fiscal years, if you actually look at it from a pure administrative timing standpoint, you had 46 last year under the Trump administration, 27 before that with Obama, 43 before that, and 20 before that. Again, some of that has to do with the nature of the workflow. Some of it may have to do, frankly, with administrations swinging for the fences, as it were, for conciliation agreements and not doing deals. We'll have to, again, see how that plays out for 2019, but certainly, at least for the last 2 years with the Trump administration, they've been fairly consistent. So where's the activity? When you look at the conciliation agreements itself, where are the conciliation agreements lying? Well, you can see that by far most of the conciliation agreements came out of the Mid-Atlantic region, almost double everybody else's numbers, followed by SWARM, the Southwest Rocky Mountain region, Midwest, Northeast, Southeast, and Pacific. Again, is that because the data and the audit activity doesn't necessitate and result in a conciliation agreement? Is that because some areas are more willing to sort of be flexible on conciliation agreements while others are not, and it pushes into litigation? It's hard to say. I think it's a little bit of both. But certainly if you're in the Mid-Atlantic region or in regions like SWARM in the Midwest, you just got to know that they've been more active in this space, and that will probably continue into 2019. When you look at the dollars, frankly, are really interesting, I think. This is a breakdown of the financial conciliation agreement settlement figures that are actually published on the FOIA reading room for the last year. And, consistent with years past, there are some things that shouldn't surprise you, but there are a few things that are interesting. When you look at these totals, by the way, they are rounded numbers. And there's a little bit of overlap between some categories. So, for example, there's a little bit of overlap in reporting between disability and termination because some CAs have both. But if you look at the numbers at the top, certainly hiring remains the name of the game. Sort of applicant sort of hiring activity, as we've always told our clients, is the number one sort of focus of audits, and that's not going anywhere. You see 27 conciliation agreements out of 46 were in the hiring space for a total of $8.6 million. But jumping quickly down to that is compensation, and there's no doubt that compensation audits have had an uptick in 2018 and prior. That was a big emphasis of the Obama administration that has continued under the new administration, for better or for worse. And you can judge for yourself the numbers. $8.2 million for compensation, that's a lot. For only 12 different conciliation agreements. And so what that tells you is, there aren't as many audits that are resulting in conciliation agreement-focused outcomes on comp, but when they come, they're big hitters, which is why the OFCCP obviously is very interested in that. Jumping on down, you'll see a handful of cases regarding disability and reasonable accommodation. Just a couple in the termination space, none for 2018 related to promotion, because promotions, frankly, are very hard to audit and hard to second guess. One small veteran case, one retaliation case, and a smattering of harassment cases. The total for the year was about $17.8 million, and if you take out the category overlaps, it turns out to be about 17.4. So certainly active, but not what I would consider to be a huge year with respect to total outcomes. Other things to think about with respect to trends, If you're looking at numbers again, the highest overall conciliation amounts came in one hiring case involving JBS, which was a multi-site resolution, hence the $4 million price tag. The other two big heavy hitters came out of compensation case, one for EMC and one for Humana. Again, that sort of tells you a little bit about relative risk. When you look at the average recovery for hiring cases, when you pull JBS out as an outlier, it turns out to be, on average, about $175,000, a little lower than you might think for some years. Likewise, on the comp side, the average comp conciliation agreement amount pulling out EMC and Humana is about $280,000. So it's interesting. When you get away from JBS, EMC, and Humana, you really don't see a lot of cases up in that amount. There's no other case in the $1 million range except those three. And after that, it jumps down to about $500,000 or $600,000, and it jumps quickly down into the threes. Again, that's interesting from a trend standpoint and from just a negotiating posture. A couple other things I'll say before I turn it over to Bill. So, going back to Bobby and Micah's thoughts about themes for the year and what OFCCP is trying to posture as, there's no doubt, at least in our opinion, that, Director Lien and others are trying to set a new tone in the administration. Whether they have the political firepower and help they need to do that, it's a separate question. But there's no doubt that, during audits, we are getting some chatter where, the bedside manner, for lack of a better word, between us and our contractors that we represent and the agency tends to be a little bit nicer. The agency interaction is a little bit more accommodating, a little bit more flexible with respect to scheduling, a little bit more flexible with respect to trying to make reasonable requests for information that they ask and the amount of time that we have to supply it. And somewhat a little bit more willing to have a dialogue about requests for information of whether the scope can be narrowed. That's nice, and it is definitely, from a contractor community standpoint, it's much appreciated. But frankly, as Bobby and Micah said earlier, when the rubber meets the road, from a regulatory standpoint, from an enforcement standpoint, we're not seeing a lot of change that really, truly matters to contractors. So, for example, they say that they're not going to go on fishing expeditions and that they're going to try and share and be more transparent, quote unquote, with respect to the reasons for requests for information. And yet, we still see on a regular basis requests for information that are extremely extensive when there are actually zero indicators, quote unquote, whatsoever on a statistical or other basis. Likewise, they promise that they're going to give us, quote, a pragmatic time to respond. Meaning sort of something that's reasonable to the scope of the request, and yet, depending on the region you're in and who you're dealing with, you'll still see these crazy 5-day requests for reams of information, plus threats of denial of access if you don't respond. Again, it depends on who you talk to, but it happens. Likewise, they talk about trying to be more consistent in treatment across similar situations across the entire OFCCP platform, but you'll still see a fair amount of varied enforcement approaches by region and district. I think the conciliation agreement numbers show that in spades. But, we see that on the ground. And then, frankly, the last two things I'll mention before I turn it over to Bill is, we still see things that, for lawyers at least, sort of drive us up the wall. They talk about the need to be more transparent, and frankly, there are cases that sort of specify sort of what the rubric is for proving allegations of alleged sort of disparate impact that are purely based on statistics. But when you get into discussions about that and ask them for the data, in many cases they won't share the data, or if there's alleged and/or evidence, they won't tell you what that is. And in many cases, you'll get into an NOV discussion, and you'll say, okay, let's talk about the legal theory. You have the following proof that you're required to proffer in the case on this. Exactly what do you think is causing the alleged statistical disparity? What practice, what policy, what procedure do you think is actually doing this? If not direct discrimination, if it's indirect discrimination through a neutral practice, what is it? So we can remedy that. Many times they'll tell us, A, we don't have to tell you that, B, we won't tell you that. And C, we'll just leave that to enforcement, which is no real way to run a railroad. But that still continues to happen. I think they've gotten a little better about that, but whether that continues into 2019, we'll really have to take a look. Because, frankly, that's where most of the disputes are, about methodology, about data, about how to look at the data in light of true business practices, and having a dialogue with the agency about that. Some officers, some regions, frankly, are just more willing than others to have that discussion. So that's what we're seeing for 2018. As far as predictions for 2019 and what's sort of keeping us up at night about that, I'm going to turn it now back over to Bill.
Thanks, Brian. Hi, everybody. It's Bill. Couple things, probably 6 or 7 things to watch out here for 2019. The key takeaway about this annual certification proposal, and this directive was issued in the summer that Mike is talking about before, is kind of interesting because it's like a directive not to a regulated community but to the OFCCP staff to work up a process for an annual certification. I think it's really important for contractors to engage with Director Lien and others at OFCCP to make sure the contractors get some kind of input on this process before it is finalized, and preferably through some type of formal notice and comment process, so the regulated community has some opportunity to give feedback in response to a concrete proposal that OFCCP would put out there, because there's lots of open questions about how this would work. The directive suggested it would be some type of annual certification, essentially that you were doing all your AAPs on the annual cycle, but it brings up a host of practical questions and challenges. Anytime somebody is certifying something to the government, you want to be really cautious and make sure you're really really diligent and responsible with that certification. And anybody, especially in large organizations that are putting together lots of AAPs, know that it's not like a clean linear process that always goes off without a hitch, and certainly not within the first 30 days of the end of the prior AAP cycle. So exactly when would the certification take place? How would that relate to the fact that people have different AAP years? What about straggler AAPs? What about corporate transactions where you're bringing in? It just raises a million different questions. The other aspect about this that's really a bit alarming, that we would want to make sure that the precedent is that they use notice and comment for such certifications, is that once they do it, it's precedential for other certifications in other administrations for any manner of different types of compliance requirements. And then they would just point back and say, well, yeah, in the Trump administration, they opened the door for these certifications, so we're just adding to it. And certainly we would want to make sure that the process for determining certifications involves full transparency and input by the regulated community to work out these very practical details about how that process would work. The focused review process that Micah mentioned as well, that has a personal interest of Director Lien, especially on the disability issues that Bobby was talking about. There's basically will be a focused review. It'll be interesting to see how they implement this and how it plays out in practice, and in particular whether it does turn to some type of a statistical or data analytic approach versus just checking whether you're engaged in good faith efforts and working up some of the technical aspects of disability and veterans AAP compliance. If they do start to focus on data and trying to run statistical analysis, it is problematic given the low self-ID rate for individuals with disabilities. and the prior regulatory commitment in the 2013 regulatory action that introduced these changes to VEVRA and 503 APs that they wouldn't be using the data that way, that it was designed only to look at it from the perspective of whether your good faith efforts are working and not to evaluate whether there's some kind of discrimination concern. So that's something to worry about and see how that's playing out. Keep our eye out for what's going on. We have every expectation that the compensation is going to continue to be the dominant worry for contractors in these audits. We're starting to see, and we think we'll see a lot more detail about over the next year about OFCCP implementing the new comp directive 2018-05, and there's some very interesting aspects of it. One listed here, basically that it really doesn't, it changes the sequence that is typical in OFCCP audit practice around compensation, where you would submit the basic item 19 comp data. They would do some kind of a screening test, and then hopefully the screening test would be realistic. Like in the past, in the Bush administration, there was the trigger test that did screen out many for that wouldn't be eligible for further review, and then that changed to more of a unclear black box approach that where we were seeing requests for pay data in almost any audit with a decent workforce headcount. Now this changes it yet again, where it suggests that the whole point of the initial submission was this screening process where you wouldn't submit more detailed data up front, and they would do some kind of a basic screening, and that the screening would be realistic. So let's say maybe half of the audits, they wouldn't follow up and request more comp data. That should be the way it works in a more tiered, structured process. But this directive suggests that you would submit the detailed pay data and more information on these so-called pay analysis groups very early in the process, and just kind of go and avoid the entire screening step of the process, which if you did that would mean every single audit that was completed would essentially involve a full comp review at the very beginning, and there wouldn't be any screening process. So that's, I think, something to see how these comp issues play out over the next year during audits. But I suspect this is going to be the area that presents the biggest challenges for contractors over the next year. The agency is talking about this early resolution procedure, this directive that came out, I think, in November or early December, that suggests that the agency would agree to 5-year conciliation agreements that would involve resolution of kind of claims that existed not only at one location but at a number of locations. And then for that 5-year period, the locations that are subject to the agreement would be kind of conducting their own self-audit approach and giving reports to OFCCP, and then they would get a buy from routine audits. But in a sense, they're going to be under a current, regular audit cycle with these reports that they have to give to OFCCP. So it's almost like they would be, in a sense, an existing audit for 5 years, because if they submitted reports to OFCCP under the agreement that showed disparities, presumably OFCCP would reopen the investigation and follow up on that. There's a disconnect with this procedure because it's designed to be an early resolution procedure where you would start talking about this fairly early in an audit, and so it's supposed to be a streamlined procedure that starts in one particular audit, but then it leads to an outcome that is much broader, and so there's somewhat of a disconnect between those two aspects of the approach. And it also sets up a worry whether or not the agency, in conducting a particular audit, is going to start now trying to push for more company-wide resolutions where you're going to start getting pushed, and the OFCCP is going to suggest leverage to seek broader conciliation agreements versus having more limited conciliation agreements. So that's something that we'll have to pay attention to and look out for as the year goes on with those agreements. On the other hand, it does set up a nice possible opportunity for some creative thinking on some resolution structures that might be worth considering and pursuing, and that's to be seen how flexible and accommodating OFCCP field officials and managers will be in negotiating those kinds of deals, and whether that is something to think about because it actually works out pretty well, or if it becomes problematic because the way it's being implemented, and if unreasonable positions are being taken. So we still see the same problems with comp. As Mike said, I did a presentation on this in December that we'll send around. They're still aggregating both on hiring and comp, including multi-year aggregation for hiring, and then aggregation in comp cases across these so-called pay analysis groups that where they really are not coming to grips with the legal doctrine around appropriate aggregation, and that's driving the agency to conduct broader investigations and to make allegations more frequently that are really not based on appropriately conducted statistical analyses. They have increased inquiry and kind of digging in on temporary personnel and staffing, sourcing arrangements, and Brian did a whole presentation at the ILG last year on this topic, and it's really a nettlesome issue because the agency really hasn't put out substantial guidance on that question, and it raises a myriad of practical issues that one could think about, and I'm sure Brian would be happy to share his deck with you on those temp issues that are quite challenging. There's continued use of like bottom line statistics to drive here's where we think there are claims, and really not looking at the full context and not heeding the Supreme Court's admonition that statistics come in all sizes and shapes, and that you have to look at the whole context and do a holistic review. They're kind of just more or less following the standard deviations around, and that's and you'll see these cases where they're saying, well, in this group you were discriminating against whites, in this group you were discriminating against Hispanics, and it was like all over the place. In some cases you're seeing every group was subject to discrimination in the same contractor workplace, and you're just kind of like, well, what? There's really no investigation or identification of the basis for the theory of discrimination in terms of a employment practice that they think is causing a disparate impact, or managers that they think are engaged in disparate treatment. It's just really bottom line statistics and then an allegation. We also, in an alarming trend, especially because this is happening in this administration, is really aggressive plaintiffs-oriented use of a media strategy. You saw this play out just over the last couple of days in kind of the hit job that OFCCP came out with against Oracle, that was in what they do, and this is a plaintiff strategy that is typical. They'll try to monetize the claim somehow, and even though that's quite improper, and then in the press they'll say, oh, this is an $100 million claim against this company, and that's you see that from the plaintiffs all the time in press releases that they file in class actions, and that's essentially now what OFCCP is up to. And we're also seeing a lot more leaks and a lot more coordination with Bloomberg, especially, where it seems like the agency career team really is leaking information, even about ongoing pending audits for which there's no other public information. We're seeing those kinds of media leaks and to put pressure on the employers. And then just lastly, you're still seeing the solicitor's office attorneys being involved significantly in OFCCP cases, and the idea that this would be a rule of law administration really hasn't come to fruition. We're still seeing the same kinds of dissonance between what the legal standards are and what OFCCP is doing in practice. So I think those are the types of things that we expect to continue to see, and that we would recommend that employers keep an eye out for, and think about ways to continually give feedback to Craig Lien and others at the department about these things, and try to keep pushing the ball in the right direction through those interactions to the extent that we can. So, Brian, I think that's it for my section. And
sure.
We should move on to questions.
Yeah, thank you, Bill. Yeah, a couple things before we jump to questions. One other item of note, there has been a lot of discussions about the PDNs and whether they're going to be helpful and whether it will really prove to be a true dialogue with OFCCP. The idea behind the PDNs, these predetermination notices, is that rather than getting popped with an NOV and then everybody squaring off into their corners and never to meet in the middle, that in theory the PDN will come out and you'll have the sort of dialogue and hopefully be able to convince OFCCP the error of their ways. We'll have to see what the data shows. We'll be able to actually look at numbers next year between the PDNs and the actual NOVs that go forward. It'll be interesting, I think, to see how many of them actually do result in OFCCP pulling back, or whether they just use it as some form of methodology to sort of force you into, quote, an early resolution. It'll be interesting. We don't know. I think the other thing that we would just note that, increasingly, especially with the changes in the comp structure that Bill mentioned, you just got to really know that, the initial desk audit submissions that you send and the data that you send to go along with it, especially the underlying applicant flow logs, it's key. Once that's out of the gate, we can certainly help you, and other folks can help you, and we can do all sorts of analysis to sort of try and put things in a more proper posture. But in many ways, once they have it, they have it. And our ability to control the direction of an audit is a lot more diminished, I would say, if we're not involved in the outset. And so on an internal basis with your in-house counsel and with external counsel, our advice remains that increasingly you really don't want to wait to involve counsel when the requests for information start flowing. I think a lot of folks think that, well, we'll just save a penny here, a nickel there, and if things turn wonky on us during the audit, then we'll get in-house legal involved, then we'll get counsel involved from outside. And under the prior administration and continuing under the Trump administration, that can be an expensive strategy. So just keep that in mind. One question I thought we don't have much time, but I'll just throw this out to the group. One individual asked a really good question about targeting. And Bobby, Micah, Bill, I'll just throw this out to y'all. The question is sort of what recourse, if any, does a company have if they believe that they were truly unconstitutionally targeted for audit. And I know we've been involved in a lot of litigation about that, and certainly from our experiences, the answer to that is not what you might expect, frankly, based on some of the rulings. I'll throw that out to y'all. Bill, Bobby, Micah, thoughts on that?
This is Bill. I would say that you first of all, you have a constitutional right to object and to seek a hearing, which is pretty unusual. So the process is actually favorable to employers in this setting when you compare it to like the EOC process, where you wouldn't be able to get a hearing on whether the subpoena would issue. They would just issue the subpoena, then you could challenge it in federal court. Here, you would be able to challenge it first before an ALJ, but it is a costly process. I mean, basically, you couldn't give the data at the same time you're making the challenge, because the OFCCP has been successful in arguing that once you provide them the data in response to a request, you've waived your Fourth Amendment rights. So you would have to withhold the data. You would have to make an inquiry as to why you were selected. You would, and then you would seek to challenge the selection, and you really can't. There were some cases where contractors sought affirmatively to get a hearing. Those cases ultimately didn't fully resolve. There was a case involving Entergy where the parties settled before a determination was made as to whether a party could affirmatively seek redress in administrative proceedings, or whether you just have to wait till OFCCP files an administrative action to seek the data, which would then allow you to contest it on Fourth Amendment grounds and contest your selection on Fourth Amendment grounds. The challenge in those cases is you don't really get fulsome discovery, and because you don't get good discovery, you have a hard time establishing that you were targeted, and you really have to come up with like a FOIA request approach, and might even have to engage in FOIA litigation to really get to the bottom of the selection process to get enough information to be able to really have a decent chance to show that you were targeted. Now, obviously, if you get 50 audits in one cycle and it's so apparent, and that's what happened in some of those cases that were filed in a couple of years ago, like Entergy, those were cases where it was so obvious because they got just a huge number of audits in one cycle. So that's the process. It can be done, but it's costly and it's difficult because it's hard to get access to discovery you need to show that you were targeted.
Thank you, Bill. Yeah, I mean, it's a hard issue, and just to point out one thing that Bill mentioned, I know we're out of time, but the key thing here is that there is really bad case law out there about the fact that once you provide information, once you share data, that you have sort of waived your constitutional sort of a claim with respect to targeting. And because I think some people in some other settings with other agencies think that, well, I can submit this information, but I'll send a letter and I'll say, I hereby submit the following data, but I'm doing it subject to reservation of my objection regarding my constitutional claims with respect to targeting, and we'll be following up on that. You can't do that in the circumstances. The courts have held, rightly or wrongly, that once you sort of open the door and provide that information, that you somehow sort of, quote, waived your rights. I'm not sure I frankly agree with that personally, but that's sort of the position that we're currently taking. And so that puts a lot of pressure on contractors if they think they're being targeted to ask a lot of questions up front. And we've done that in some circumstances. We have done letters back to OFCCP when we've gotten audit notices that say, great, thank you for the lovely invitation, but we have a lot of questions about how we got the letter to begin with. Please help us understand the following 10 things. And that doesn't always generate what you want. but you just got to know the timing of that is very important. And if y'all need help with that, certainly folks at our team are glad to talk with y'all further about that, because I think it's increasingly going to be an issue. With that, I think we're out of time. We want to be respectful of everybody on this call. Thank you for joining us. Thank you for participating and for the questions that you raised. If we did not get a chance to get to your questions, we will follow up with you individually after this webinar. And certainly you have all our contact information, both in the written materials and in the e-bite that was sent out earlier, to the extent that Bill or Bobby or Micah or myself can be of any help to you at any time. Certainly give us a call. Most everybody on this line, frankly, are our clients or our firm clients, and we're glad for that. And we're more than happy to pitch in as much or as little as you like. Likewise, if you're not our firm clients and you're joining us, we're happy you're here. But we'll be blunt, we want to be your lawyers. And so if we can help you in any way, don't hesitate to give us a call. Thank you. Fingers crossed for the years ahead and for 2019. And we hope everybody else on this call has a great afternoon. Take care.